NSA collects everything, word for word, content of every phone call communication, of every email.
When national security letters are issued, they allow federal agents to conduct any search on any American, no matter how extensive, how wide-ranging, without ever going before a judge to prove that the search is necessary.
In early 2004, an FBI agent visited Nicholas Merrill. Under the law, recipients of the letters are barred from telling anyone about their encounter with the FBI.
All that is needed is a sign-off from a local FBI agent. That's it.
The other problem, though, with the letter was that it told me that I could never tell any person that I had received the letter, which pretty obviously precluded me from speaking to a lawyer or to anyone else in my company or to anyone about it.
And they're even prohibited from challenging this automatic gag order in court.
The FBI had not gone to court. It had not proven probable cause before a judge. And
even though judges have already found that similar restrictions violate the First Amendment.
And the letter demanded that I hand over a lot of information about one of the clients of the company.
And if someone wants to know why their own government has decided to go on a fishing expedition through every personal record or private document through the library books that you read.
Librarians had also received a national security letter in Connecticut for library patron records.
This is just plain wrong. I will provide our intelligence and law enforcement agencies with the tools they need to track and take out the terrorists without undermining our Constitution and our freedom. That means no more illegal wiretapping of American citizens.
The first thing that sort of really shocked me was that this was not a court order. This was a letter from the FBI. It was not a court order. This was a letter. The problem was, though, we were never able to get to the Supreme Court to get a final binding ruling that would affect the whole country. And to be honest, it felt to me like the government wasn't really acting in good faith, that when it seemed like they were going to lose, they would back out of all these cases. They were afraid to have the Supreme Court rule on the issue itself, afraid to have the Supreme Court rule on the issue.
We thought it would be cool to offer, you know, a free private email with a large quota, just like Gmail. And we sort of built the service along those lines. Why I chose to take the extra effort and build in the secure storage features and sort of focus on the privacy niche. If the government had learned that I was shutting my service down, can I say that?
Well, I think it's best to kind of avoid that topic, unfortunately, for fear of being dragged away in handcuffs.
What's at the heart of this matter here, the 800-pound gorilla in the room is warrantless wiretapping and surveillance of Americans without any suspicion of wrongdoing. As we've heard with the revelations from Edward Snowden, this is a very widespread problem.
Unfortunately, I can't talk about that. I would like to, believe me. I think if the American public knew what our government was doing, they wouldn't be allowed to do it anymore.
No judge will hear your plea. No jury will hear your case. This is just plain wrong.
I don't have to show you any stinking badges.